Linda, the warmest welcome to the Cardiff Centre of Legal Research conversation around our theme of socio-legal research. You are on the threshold of becoming director of the Oxford Centre of Socio-Legal Studies, or for Socio-Legal Studies, and this is something we at Cardiff have a great interest in, and we're hoping to discuss your understanding of socio-legal research. So my first question, Linda, is how did you get into socio-legal studies?
Okay, I'm not sure how far back you want me to go, but in terms of my qualifications, I started with a law degree at 18, very bright-eyed and bushy-tailed, worried about justice, and I went to Southampton University from 1981 to 84, which I now look back and realise actually it was a really fabulous degree for me to do there because we had to do the compulsory subjects. But there were so many options that I now realise were socio-legal or critical legal options. And I've spoken to people who were at Southampton teaching there at that time since, and they said to me they thought that was quite a golden period of about 8 or 9 years. So that was fabulous for me because I enjoyed the doctrinal work, and I think we all have to be good doctrinal scholars to be good socio-legal scholars. But the issues that were raised didn't quite speak to me in the same way, but I found that when I did courses on law and discrimination and environmental law and welfare law and poverty law, those were issues I think that I just felt more passionate about, really, that sort of outsider perspective on the legal system, which of course is really important for any socio-legal scholar. Of course, I didn't even know what socio-legal studies was then. And in fact, for my dissertation, I remember my supervisor, David Carson, suggesting to me that I did something empirical, and I had to go and look the word empirical up. I didn't know what it was. So that's quite an interesting start. But I then had a gap for a couple of years and went to the LSE to do a postgraduate degree in law and social theory. And then I subsequently moved on to do my PhD again later. I had a gap again. It wasn't common, as you know, in those days for people to have a PhD in law faculties, but one of my friends who was a sociologist and a feminist said to me she thought it was really important for women to get PhDs and to have the doctor in front of their name, and I took her advice and did a degree in sociology, a PhD in sociology on disputes between doctors and patients. And then I'm sorry, this is a really long answer to a simple question, but my desire to get educated, I sort of come from what one city law firm once called a very modest background. I just felt I had enormous gaps in my education. So I subsequently went back and did some work on architecture, did a foundation degree in architecture, and then did a conversion course on history of art, and then a master's in the history of art and architecture at Birkbeck, which I just did a few years ago. So I don't know whether it stopped yet, the education, but that's certainly the sort of journey I took through different disciplines. And I suppose the real interest for me in all of those things was, I love methodology. I teach methodology at the moment, and will carry on that specialism when I move to Oxford. I'm really interested in learning how different disciplines see the world and what sorts of questions they ask, because I just think it helps us to be much more aware of how, as lawyers, we might limit our questions. We might ask a limited set of questions because we're looking at law in a particular way. We expect certain things of it. We think of certain types of questions as being legitimate. So for me, it's endlessly fascinating to do methodology courses in sociology or art history and architecture and just understand different ways of seeing, really. I think it's a good discipline.
I wondered where you were going to begin because it was an open question, and to say that your journey's been modest, or you came from a modest background as well, it's not quite as simple as that, is it? You had a very interesting pre-university education. So you went to a Steiner school in Hertfordshire.
Yeah.
Is that right?
Yeah, in High Wycombe, actually. It was in the 60s, and it was a failing school. I mean, nobody was passing their 11 plus. I think my sister had been the last person to pass her 11 plus, and that was 4 years previously. And it was seen as a failing school, and it was the 60s. And so they sort of reorganised the school and the principles according to which we were taught and turned it into a Steiner school. So resources were lavished on it, actually. We had a farmyard at the school. We had computers, which was really unusual. This was in the 70s. They were very clunky, but there was quite a lot of resource. We had new buildings constructed, which meant that there weren't classrooms, there were just different areas. And yeah, it was really revolutionary, actually. I mean, you'd go in the morning, you didn't have to do any subject. There was a list, and you would fill in at the end of the day whether you'd done maths or English or a bit of design work. I spent a whole year making baskets, I remember. I was really mad, actually, about that style of education for quite a while, because I think if you come from a disadvantaged background and you go from Steiner, then you have to go back into mainstream education. That's quite difficult, because I didn't pass my 11 plus, actually, but I got in on appeal to a minor girls' grammar school. And it was really hard for me to cope with that grammar school, because everything was very rule bound. And of course, Steiner schools sort of teach you to be a little bit disrespectful of rules in a healthy way, but to question them, etc. So it's quite hard for me. And I think my teachers thought I was smart, but I wasn't trying very hard. And I don't think that was true. I was trying really hard, but I just didn't know what the rules were in this girls' grammar school. And I remember there was a point at which I was quite a rebel at school, and I think that came from the whole Steiner thing of questioning everything. And one year I decided that I was going to prove my teachers wrong, and I was going to come first in a subject. So I came first in history one year, and that incensed them even more, because it sort of confirmed their view that I was smart but lazy. Actually, the reality was I couldn't cope with studying all these subjects as hard as I needed to get first. And then I came first in social sciences the next year, and then first in geography. I just choose one subject a year just to wind them up a little bit. But the funny thing about all of this, I think, is that Steiner has become more valued in my eyes as I've got older. I mean, I got to university and I thought, oh, wow, this is great. It's just like a Steiner school again. People are questioning rules. We're allowed to have outsider perspectives. We're allowed to have opinions. So it was great. I felt it disadvantaged me for a number of years. I think as I get older, I realised it was a real advantage, because, again, it's a particular way of seeing things. And I think it does make you question rules and the basis for rules and how we live together as a community, and we value people for being good at different things. So, yes, it's been a funny relationship I've had with Steiner education, really. Resentful about it for a number of years, but I've come to peace with it now. So.
But that's a wonderful background, and a bit later I'm going to pick up on that theme of rebelliousness in your early education, and whether that translates into your research output at all, and your attitudes towards the legal academy. But you're a socio-legal studies professor at the Oxford Centre. We're a socio-legal studies oriented university, but what does the term concept mean to you?
Oh, I think that's
how broad is it, for example?
Yeah, well, it's a really broad term. I think it has become a really broad term. I think the socio-legal movement is a very broad brush one these days. And I think if we judged what socio-legal studies is by going to the conference, we'd get a sense of its very broad church. So I see people coming to the annual conference now who I would say, do quite doctrinal work or critical work. And I've talked about that with colleagues. I'm a former chair of the Socio-Legal Studies Association. I think the view is if people feel comfortable at the Socio-Legal Conference and they want to have conversations with other socio-legal scholars, that's great. But I think it has become quite broad. In my day, I suppose I think of myself as a second generation socio-legal person. I think there are people like Phil Thomas and Mavis McLean and Keith Hawkins, who were the first generation. And in a way then it was easy to know what socio-legal studies was. We were mainly doing empirical work, which in itself was a strange thing to be doing in a law school. We were interested in the insights from other disciplines. So I think there was a closer tribe then, and now it's become so broad-based. For me, what is at the core of socio-legal studies is drawing on the insights of other disciplines when studying law and legal phenomena. And I think that could mean that socio-legal studies is a social science, and it could mean that it's a humanities subject. And in fact, I think that there's been a little bit of a humanities turn in socio-legal studies, but I think it's just drawing on insights. And for me, drawing on these insights doesn't mean, which I think it can sometimes be interpreted as, it doesn't mean stealing a method or methodology or theory from another discipline and running off with it and just applying it to law. I think it's one of the reasons why I kept on studying different disciplines. I think you need to be properly embedded in those disciplines and understand perspectives and research questions and histories of those disciplines to really begin to do interdisciplinary work. So I think there's a lot of training involved, in my view, and a lot of reading to be done in when you're a socio-legal scholar, because you're going beyond the confines of what are the comfortable texts for you, because that's where you start as a lawyer, really.
Yeah. Can you give an example of how you've used, say, law and the history of architecture? Was it the history of art and architecture that you studied at Birkbeck?
Yes, that's right.
So how have you used that experience to bring two disciplines, if you like, together?
Well, I suppose the first thing I found out when I was doing the art history degree was that actually a lot of the texts that we were studying in our methodology course were very similar to the texts that I would set my students when they're learning socio-legal studies. So the same great social movements and social scientists, humanities scholars that have had an enormous impact on all our work: Foucault, Derrida, Bourdieu. And we look at them across disciplines, of course we do, because these have been enormous contributions that they have made to the academy. So when I was doing my art history degree, we would learn about Marxism and feminism, and I thought, I'm familiar with all of this. But of course, you look at it, you're using them in slightly different ways. And one of the things that I learnt from the degree in architecture and art history was how to look at things and how to value looking at things. I was criticised in some of my early essays for using images as though they were examples of arguments that I wanted to make in the text. And I think what it taught me was that I need to look at the image or the building as a thing that is deserving of attention and understanding, that it's not just an example, it's not just a pictorial visual example of something, another argument I want to make, that you've got to treat it as data, really. You've got to really spend time with it. Somebody said to me yesterday that the art of looking is a lost art in many ways, although that's quite strange because we're so visual these days as well. But I think it's been tremendously useful in my own work because visual methodology is so important to all of us. We look at so many things through pictures, and social media encourages us to do that, iPhones, and I think that's really important to law, to understand how law comes across through the image and the images that are produced about law, and how that communicates to people in a certain way. I mean, I find it interesting that we're actually visually quite illiterate in this country. We're not taught how to look at things. We do art, but it's not a compulsory subject. And yet we are taught how to write. We are taught how to read and write, but we're not taught to be visually literate. And I think that's a problem, actually.
I'm thinking about your use of photographs in some of your legal research. And can you elaborate on noticing things through looking and something visual being intrinsically valuable, rather than an example of an argument? So can you talk a little bit about your use of, say, photography in legal research?
Yeah, I mean, I've become really interested in mugshots, and in a way that's quite an overly populated area. A lot of criminal justice and criminologists have looked at mugshots and been interested in them. And I think there's a certain orthodoxy that has developed about mugshots. People tend to look at them through a Foucauldian lens, which I think is a completely appropriate lens to look at them through, that they render the bodies of criminals docile, that they tell stories of the exotic, of people of colour, of mad people, and that it's about how the culturally empowered or socially empowered marginalised or categorised people. And, the wonderful thing about mugshots is that you can take mugshots out and arrange them in different ways. So they get arranged in police lineups, or they get arranged in albums in prisons, or then they find their way onto the market. It's very easy to buy mugshots, old mugshots, and artists use them and do things with them. So I think Catherine Biber, UTS, would say they have a cultural afterlife as well. But I was interested in this sort of orthodoxy about the state through the taking of mugshots, and it's often quite a violent act because people don't always want their mugshot to be taken. So there is violence involved, and you can see people being restrained in some mugshots from the Victorian era. But also what's possibly even more depressing is when people are just completely docile, they've sort of given up the fight. And, you can see these very sort of depressed and oppressed people whose photograph has been taken against their will. So I think that orthodoxy about rendering bodies docile and the power of the state and biopolitics is a really important one. But I think what we lose from that is this notion of resistance through the mugshot. And resistance is something that Foucault was so interested in. He said we can only spot power through resistance. And yet I think art historians, when looking at the mugshot, had tended to think of it only in terms of one aspect of the way that Foucault looks at it as rendering bodies docile. So one of the things I've been interested in is looking back at mugshots and seeing if I can spot resistance. And I think sometimes that's physical resistance, sometimes it's the shutting of eyes, and sometimes it's a bit of a look that people will give you to say, you've captured me on film, but you haven't captured me. I'm still here, and I'm still angry, or I'm still, not complying with this process. And that in itself involves all sorts of descriptions about how do you know when somebody is trying to resist. Perhaps it's just that the cameraman has made them laugh, or the cameraman's made them angry just before the shot's been taken. But I think there's an interesting discussion to be had, really. If we look at those photos, can they also tell us stories not just of complicity, but of resistance? So that's one example, rather long one, I'm afraid.
And on the theme of noticing it and art, I mean, you're currently looking at courtrooms, aren't you? And the physical space and its relationship with justice. So can you talk a little bit about what you're currently finding, maybe how you've gone about the research, your methodology, and what's coming out of it in terms of findings?
Well, I've been working on court architecture for about 10 years now, and I'm just about to bring my second book out, which I think is going to be the last thing I write on it, because I think I've solved the puzzle that I set out to solve. And also I'm getting a bit bored of my own arguments, so I need to move on and do something new. But the first book that I wrote, I suppose, presented something of a paradox, which is, it seemed to me that if you trace the history of ideas about courthouses, and the wonderful thing about courthouses is we have a really rich treasure trove. We have an archive of buildings that we can go around and look at and think it's interesting how people are positioned in relation to each other. So why is it in Manchester assize courts, which is now destroyed, but there were lots of bas-reliefs of forms of medieval torture in the public area? Why was that appropriate in the 1840s when that was built, and we would now think that that was inappropriate in a court in the early decades of the 21st century? So I'm sort of interested in the history of ideas about court design and why we used to have open docks or no dock, and suddenly we have the necessity to have very closed docks, often glass rooms within the courtroom. So the paradox that I sort of tried to unravel in my last book was, why is it, as we have moved towards a democracy, have our courts become less democratic? I mean, barristers used to stand shoulder to shoulder with the defendant in the courtroom, and then suddenly there was this moment in the early Victorian period where they started sitting in front of them, and the defendant increasingly gets marginalised in their own trial. How did that happen? How was it justified? How was it rendered legitimate? What were the conditions of possibility that made that a legitimate thing to do? So in the book that I'm writing at the moment, what I've done is a much more intense analysis of the period from the 1970s when we first had a centralised design guide. And what I'm interested in analysing there is how civil servants, lawyers, architects, engineers talked about justice in the corridors of Whitehall behind closed doors, and what courthouses got produced as a result of that.
And how big a part is the local courthouse? You're almost giving the impression of a national, UK-wide, how to design a court in the 1970s. But isn't it the localness of some of the courtrooms that is important to the nature, the justice? How local are courts? I mean, are you studying a court, if you study it in Hertfordshire, it could be anywhere in Britain, or how local?
Well, I think local courts are really important, and that sort of grassroots experience of the local court. In fact, the whole notion of what is a local court is pretty much up for grabs at the moment.
Yeah,
but suppose what I've been really interested in is the development of this centralised design guide. There were 10 produced from 1970 to 2010, which was because we had a centralised justice system after the Courts Act in 1971. It centralised responsibility for courts in the Lord Chancellor's office. And they started to produce, with this multi-departmental working group, a series of design guides which prescribed how courts should be built at local level. So there will be some architectural discretion at local level. You might get a different facade, a different public hall, but the courtrooms will actually be the same, and the circulation routes will be the same. They will comply with the design guide at the time. So I think in a way it's another project to actually then go around and look at all those courts. I do a lot of visits to courts, but that hasn't been a really important bit of the current project. What I've been looking at is how has this central guidance been produced, which everyone then had to comply with. But what I will say, which I think is relevant to magistrates, county court, Crown Court, is, I think socio-legal scholars are really good about getting down and dirty on the streets. And I'm not looking at appellate courts, and I'm not looking at international courts. And I think those would be fantastic projects for somebody else to do. But I'm interested in the everyday courts that people use. I'm interested in mundane things, which I think is what socio-legal studies is often very good at, looking at these mundane ways in which power operates in the legal system. I'm interested in waiting rooms. How comfortable are people made in waiting rooms? It's where they spend most of their time in a court. And if they are put on really hard metal benches that are screwed down to the floor, as they are in Manchester Civil Justice Centre, which is one of our most recent courts to be built, what does that say about the respect that we show ordinary people in the courtroom? So the concept that I'm playing with at the moment is notions of the jurisprudence of design, what principles that come from law and notions of due process and dignification and those things that we hold dear as lawyers, how, if we put those principles first, what sort of courthouses would we have? I don't think we have put them first since the 1970s, and I think that's a problem. I think we need to develop a jurisprudence of design to say, what do we want to achieve here? Who is being dignified? If we're in a democracy, should barristers have much better facilities than the public do? Well, how has that happened in a democracy? I'm not saying that people shouldn't have good facilities, but I think they should be equal in terms of the level of comfort. So I think court design symbolises in many ways the relationship. It symbolises what the state is thinking about justice, how much it values justice and how much it values different types of people. I think there are lots of hierarchies in the courthouse. I don't think it's a public space. I think it has public bits, and I think it's a series of private zones that aren't accessible to most people. I think it's an unknowable public building, and in that sense perhaps it isn't public at all. Perhaps there's just a lot of the courthouse that is secret. So I think that it symbolises a lot about our relationship at any one time with justice and the people. But I also think what's interesting about court design is what some people would call affordances. What does design allow you to do? What clues does it give you about how you should behave? And what types of behaviour does it make difficult? So I think it's quite difficult to participate in your own trial. And I think that is reflected in the way that we position people in space in the courtroom. I think we marginalise the public. I think we marginalise defendants. I think we marginalise victims. And you can see that from a floor plan. That's what I find so interesting about court design. That's something you can read from the floor plan. And you can begin to ask questions about, why is the barrister 3 rows in front of their client with their back to them? How did that happen? It means that the client can't have a subtle word with their barristers. How did we get to a position when we thought that was an acceptable thing to do in a courthouse in a democracy?
Can I, look at the bigger picture of architecture and democracy? I mean, there's been quite a big debate about Parliament at Westminster and the design of the building. And do you think the court architecture says anything about the relationship between the courts and more political institutions such as the legislature? Is there within the key actors of the Constitution power struggle going on here at all? Because Parliament at Westminster is a grand neo-Gothic building, rebuilt in the 19th century. Parts of it date back to the 12th century. I mean, it's a big, imposing, building.
Yeah.
But the courts you're talking about are more discreet, more uniform,
Well, that's
less
changed.
individual.
Yeah.
Does that, how do lawyers and judges feel about that, do you think, in relation to the political institution there at Westminster and to an extent Whitehall?
I suppose really those things come into play when you're talking about the Superior Courts, the Court of Appeal and the Supreme Court. I mean, I think we have a very modest Supreme Court in this country. I've just been to see the High Court in Canberra and, the Constitutional Court in South Africa. These are amazing buildings that, are beautiful pieces of architecture. And our Supreme Court is in rather a modest building. It used to be Middlesex Guildhall. But I think what is significant about that building is it sits opposite Parliament. It's not very big, but it does sit opposite Parliament. I think that's a really important symbol for us. So I think some of those debates come through much more when you're talking about superior courts, Supreme Court in particular. But I mean, I would say that attitudes have changed since the Victorian era. I mean, the Victorians lavished resources on quite minor courts. And, we will still see them in our cityscapes and our civic landscapes. And they're notable buildings and we know their courts. So something like Liverpool St George's, the St George's Hall in Liverpool, they spent so much money on that, so much more money than they needed to. It's both a concert hall and law courts. It's dedicated to arts and culture. I believe some of the money for that building was actually raised by second-generation industrialists in Liverpool who were concerned that people were saying that Liverpool wasn't a very cultured place. It was just the docks and money and industrial money, and they wanted to do something about that. There was a civic pride. And it's not uncommon for them to have lavished resources on quite minor courthouses. I mean, the St George's Hall housed the assizes, so it was a really important regional courthouse. But, sometimes you see very lavish county courts and police courts, quite beautifully designed. So I think those attitudes have changed. And they will change again as we move into an era of digital justice, where we are talking about pop-up courts or video-enabled hearings, where people aren't all necessarily meeting in one place. They might be in a hotel room or their sitting room, or the judge may be in their study. So I think it's a really important question. I think we've seen different attitudes over time, and we're just about to go into an era where we're seeing the dematerialisation of the courthouse, or what some people would say is dispersed courts, that people are appearing in court from different spaces, but they're not inhabiting the same space. So, yeah, I think there are interesting debates still to be had about that question. But Judith Resnick at Yale would say that she thinks that court architecture in the 21st century sometimes hints at a failing faith in the justice system. As we're, of course, seeing the vanishing trial, we've had lots of court closures in this country. She would say it could suggest to us that there's a failing faith in the legal system. And Hazel Gahan has also spoken in her Hamlin lectures about the poor state of many county courts, how they're quite squalid, and that says something about the government not thinking that those places are important. They don't have a place in the legal or political imagination.
Do you broadly agree with that, or is that a concern of yours? Or
I think courts are really important places, and I think there are all sorts of ways in which we could make them better. I mean, we're living in an era when we're worried about the democratic deficit, okay? And you and I are part of the problem. We're part of the metropolitan elite, okay? And people are feeling very remote from the sort of stories and lives and politics that we enjoy. And I think Socio-Legal Studies has a really important part to play in helping people to understand what it feels like to have justice done on you. Not to be part of the system, but to be subjected to justice. And I think there are ways in which courthouse design and the presence of courthouses in the civic landscape, not shopping centres, which have become our new public spaces, but a part of a civic landscape, can be really important in enhancing democracy, actually. I mean, there's all sorts of research that's done on jurors. If you've been a member of the jury, you're much more likely to vote. You're much more likely to be involved in a community group. This is Tocqueville's idea when he visited America to look at how they enhanced democratic practice. It's not just about exercising your vote, it's feeling that you have a stake in your local community and feeling you have some responsibility, and that you have a part to play in it. And I think courthouses could be designed to make people feel that this is part of their justice system, and they have a really important stake in that, and that their voices will be heard, and that they are encouraged to participate, and that they will have easy access to their lawyers, and that people care about them because they can tell from the waiting area or the cafe that this is an important space to be. So I think when we let courts go to rack and ruin and we have odd chairs and scuffed paintwork, it just suggests to people we don't really care about your rights. There's a statue in front of Middlesbrough court which worries me, and I think it's a really important statue. It's of Justicia, who looks like a harassed mother with 2 squabbling children, and she's just about to bang their heads together. I think that's a really distressing symbol of justice in the 21st century, that litigants are squabblers, they're being petty, they're being infantilised, and that basically they should go away and just have their heads banged together and sort their disputes out rather than bothering the state. It's a depressing vision of justice, I think, that we shouldn't use the courts.
Yeah, it's fascinating hearing you talking what seems to be largely about criminal justice, but some of your early research was in the field of civil justice. You're a contract law expert, aren't you?
I'm not an expert at all. No, I just did bits and pieces of contract. I picked it up as one of my core subjects early on in my career, and I wrote an introductory book on contract because I remain concerned that contract law is mainly dominated by doctrinal texts. I think it's really important to have doctrinal texts, but we don't seem to have a mixture of different approaches that we can offer students. So I sort of wrote a contract in perspective book as a part of my duty as a socio-legal scholar to make sure there was something for students to read. I mean, you can't understand contract unless you understand the concept of property that we have, that it's possible for people to have ownership, private ownership of things, and you can't understand contract unless you understand the marketplace, and that that's what the doctrine of considerations about, and adequacy and sufficiency, and those terribly technical terms we use, is about the marketplace saying it's for you to say what value. That's what we believe in a capitalist market. You tell me how much you want to pay for my car, and then you will tell me what it's worth. So I think contract law is such an important subject to have a social and political context to it as to why we think contract is even possible. It's even possible for me to exchange something that I own, that I can say I own, and I have a right over, that we don't have communal rights to certain things and objects. So I tinkered a little bit with contract law, but I would never say on film that I am a contract law specialist. I'm up for undergraduate teaching, really, but not beyond that. But I did look at private law, you're right. So I did a lot of work on medical negligence and the way that users of the litigation system talked about their experiences, and really around notions of procedural justice, how they were treated, their journeys through the litigation system. And I also then talked to doctors about their journeys through disputes and how they came to understand or rationalise mistakes that they had made, or how there had been a breach in this relationship with somebody that they had once cared for in a professional context. They were there to look after them, and something had gone horribly wrong. So some people think that I had a shift in my career when I stopped doing medical negligence work and started doing architecture. But for me, it's part of the same thing. I'm interested in the phenomenology of law. I'm interested in how people experience law, how they talk about it, how buildings constrain them, how procedures constrain them, what makes them feel involved, what makes them feel valued. So for me, architecture and medical negligence are completely the same thing, because they're about an approach.
I think this illustrates how deeply and for such a long time you've been engaged with socio-legal research. You were talking about contract law, medical negligence to an extent, criminal justice. So my question really, you received an award from the Socio-Legal Studies Association last academic year, didn't you, for outstanding contribution to the discipline. My question is, where do you see the discipline heading? Is socio-legal studies in a particularly good state of health at the moment? What challenges does it face? And I suppose a third question is there anything you think other institutions, Cardiff, for example, can look forward to in the future? I mean, what challenges of socio-legal research in the state of health?
Yeah, I think it's a really interesting place. I think there are lots of people that would say that socio-legal studies now dominates law faculties. I don't think that's true. I don't think it dominates the syllabus, but it's respectable. We no longer have to make the big case. I think we felt a lot more like a tribe before, because there were people that were very critical of socio-legal approaches and didn't think that socio-legal studies belonged in law schools, and that's within my lifetime. So we're in a comfortable place now. We've got an enormous association. We have a fabulous 3-day conference, Law and Society associations in America, in Canada, in Australia, in India, New Zealand. It's fabulous. It's really, really fabulous place to be. But I think if we go back to that question that you asked me about broad church, I think we have to think really about what socio-legal studies hasn't done. I think that's the way forward. Also thinking that there are certain subjects that we haven't tackled. I would say, for instance, that commercial law, financial law, you will find very few socio-legal scholars working in that field. And I think that's a problem, to leave legal discourse in that field entirely to doctrinal lawyers. I value my doctrinal colleagues. I hope I can be a good doctrinal scholar when I need to be myself, but we need a variety of perspectives. That's what makes the academy so rich, so we can have different sorts of discussions. So we've been very good at social welfare law, at housing, at civil litigation, issues around gender. I think we've really, family law has always been an enormous area where there's been socio-legal work has had so much influence. You can't teach family law without referring to socio-legal work in the field. But I think we need to think about going for some of those targets that we have not gone for, because financial law has as much impact on the disadvantaged as anything. We know the world is a complex place. Corporations are larger than states. We're talking about transnational law. So I think we need to move into some of these areas and claim them for our own, rather than just retreating, I think, sometimes into social welfare, because we know there are a lot of other socio-legal scholars working in that field, and it's a comfortable space for us to work in. So that's certainly one area that I think we should be thinking about. And I think the other thing is that there is still scope for more rigorous methodological training. There was a report by the Nuffield Foundation, as you probably know, over a decade ago now, saying there was a lack of capacity in the socio-legal field. It explains that lack of capacity partly in relation to the funding structure of the Oxford Centre changing. So that's something I feel is part of my mission when I go to Oxford, is for us to really play a leading role in high-end methodological training and making resources available for the whole community. And that's something I'm hoping to work with my friends at Cardiff on, which is Cardiff has always had such a strong role in socio-legal studies. And there are people here like Phil Thomas, who has been an amazing mentor to my generation, so generous. And I ought to say, by the way, I think that award from the Socio-Legal Studies Association was less about my work, my outputs, as it was about the fact that, like Phil Thomas and Mavis McLean and Sally Wheeler and Dave Cowan, we've just always done a lot of stuff together. We've run conferences where we had no money and we made the sandwiches. I remember Sally Wheeler and I going off to Asda one night to get some cheap fruit that we could give people for breakfast the next morning. I hope that's what the award is about as well, because I think one thing that we need to really cherish in the socio-legal communities, I think we have been really good about nurturing early career academics and making ourselves available to them. That's something I'm probably most proud of. I hope that's what the award came for. I feel that I'm really committed to early career academics, and I hope that the people that I have been in contact with, I've been doing a national masterclass in socio-legal studies, socio-legal methodologies for the last 3 years, which I've been running with a number of sort of prominent socio-legal scholars, and people give up their time for 2 days. They don't get paid for it. They give up their time to talk to early career academics about their research and to workshop the students' ideas and to talk about the underbelly of socio-legal research, the problems that we don't talk about, that don't come out in the highly glossed and well-crafted articles.
So there's something that's been fascinating me about reading through your profile and some of your research, and you sometimes talk about this being a revisionist piece. Now, this is probably not for everyone, but revisionism to me is sort of a slightly right of centre. It's, you're rewriting history, you're denying the progress of recent years, for example. What do you understand? You use it 2 or 3 times in articles that I've come across.
Yeah.
I mean, are you a revisionist, and what does that mean? Is this the rebel in you?
I didn't know about that association of the terms, so I probably used it completely inappropriately. Perhaps it has more common sense meaning to me. I suppose that body of work really grew out of conversations that I began to have with David Sugarman. We put together a special issue of the Journal of Law and Society on marginalised legal lives a few years ago. And David and I didn't know each other before that. We started having the conversation. We became friends in the course of producing that. And so we've carried on the conversation. It's been a joy to work with him. And David has this view that socio-legal studies has had a very uncomfortable relationship with history in the past. David is, of course, a wonderful, one of our, preeminent legal historians. And he thinks the reason for that is that, early socio-legal studies, had very much a left-wing flavour. I would say that a lot of the early socio-legal pioneers were those people that had benefited from a high expansion of higher education. Different people began to teach law. They had different political viewpoints. They began to challenge orthodox, conventional ways of doing things. And they were suspicious of history because history is written by particular people, about particular people. So to the extent I use revisionism, I suppose it's a way of saying these are lives that haven't been talked about before. So I've got a wonderful PhD student, Devora, who has just finished an oral history project with the British Library. We co-supervise the British Library and I on Crown Court clerks. Okay, so we realise when we're talking about biographies or autobiographies, they're all written by judges or barristers, and that's great. That's really rich. But what about other stories about legal lives? What about these Crown Court clerks who've hardly ever been written about? And they're absolutely central to the trial. They're the judge's representative when the judge isn't in the court. They swear in the jury, they take the plea, they go behind the scenes to the judge. I mean, they came out with these really, really rich stories and then had so much to contribute to our knowledge of the legal system. So I'm interested in telling stories about marginalised legal lives and sometimes looking at things and saying, well, actually, if we take a feminist perspective on this, there's an absence in existing archives or in existing stories. And I think that raises all sorts of interesting questions for socio-legal scholars about the sources that we use, because often marginalised lives are those that haven't been documented, working class lives, people of colour who haven't been able to achieve because of discrimination in the system and fulfilled their potential in the way they should have done. So we won't find them on the Court of Appeal, or we won't find them on the Supreme Court. So where do their stories go? Because they're not part of the public record that is kept around those preeminent lawyers. So it's revisionist in that sense. It's about saying, there are accounts of the 1970s, 1980s, 1990s that we have from leading jurists. But actually, what are the other stories of law that were going on at the same time? If you're not looking at it from the Supreme Court, Court of Appeal or High Court, what about if you're looking at it from the bottom up? What does it look like to those people? And I think that produces challenges in terms of sources. But, there's this wonderful book that's come out, the Legal Landmarks book, that was edited by Erica Reckley and Rosemary Akamuti, which tells 87 really important stories of firsts. Women who were first, women who challenged the law and set precedents, trade union disputes that changed women's rights at work, statutes that changed women's rights. And that I would see as part of a revisionist socio-legal history. And I think it's really taking off. And I think, so that difficult relationship that David Sugarman talked about between legal history and socio-legal studies, I think isn't a difficult relationship anymore. I think we are finding a way to engage with historians and historical sources in a much more creative way.
Well, Linda, it's been wonderful talking about your own lived experience in the field of socio-legal studies, a life in socio-legal studies, ongoing. on behalf of the centre, thank you so much.
Thank you for having me.